Okay, we're live.
My name, my name is.
Hey, good afternoon, everyone, or morning, depending on the part of whichever part of the world that you may be in. Um, as a convener and moderator of today's session, it is my pleasure to welcome you all to this important training. Now, given the numerous economic, legal, and technological development, the integration of information and communication technology (ICT) into dispute resolution processes has become indispensable. More so that the current global dispute resolution structures exposure to the COVID-19 pandemic has increased the reliance of technology by businesses and governments, and the pandemic has changed the world tremendously, as we all agree. And the use of technology in dispute resolution has become what we now refer to as the new normal. Although Africa is still experiencing some sort of challenges, and for those of us that are practicing in the continent will all agree to this, challenges relating to incorporation of ICT and artificial intelligence in the dispute resolution process in the continent. Although COVID-19 in a way has catalyzed the necessity of access to reliable technologies. So the primary purpose of online dispute resolution, as you will soon hear from our panelists and speakers, is to allow parties to resolve the disputes with the use of electronic technology, ICT, and these may occur in real time or in an asynchronous manner, depending on the rules of the ODR provider as well as the wishes of the party. So this process sometimes, or most times is, convenient, cost efficient than the in-person or face-to-face meetings, whether you're doing negotiation, mediation, or otherwise resolving existing dispute between business to business, business to consumers, consumers to consumers, or business to government. So the purpose of today's training, we've designed it to help small and medium enterprises and practitioners, to understand the characteristics and objectives of online dispute resolution, the advantages and the disadvantages of ODR, how to shift traditional ADR techniques, which we are all used to as practitioners, and handling disputes remotely, and how to navigate the different legal and technical issues arising from ODR. And we have lined up some of the finest practitioners in Africa to speak to us today, and I do hope that we'll find the session entirely rewarding. Now, starting with Professor Dr. Wahab. I told him before the session, Prof's bio is staggering and remarkably long, so with his kind indulgence, I will just read out an abridged version. Professor Abdel Wahab is a chair of the Private International Law Department, Cairo University in Egypt. He's also the Dean of the Africa Arbitration Academy, Vice President, ICC International Court of Arbitration, Secretary of HICA Governing Board, founding partner and head of international arbitration, construction and energy at Zulfikar and Partners in Egypt, member of CIAP's Board of Trustees, member of the International Council on Online Dispute Resolutions Governing Board. I'm sure we are happy to have Prof today, given his relationship with ICODR. He's also the former vice president of the IBA Arbitration Committee, former chair of CIAP's Technology Subcommittee, and it goes on and on and on. Prof has served as arbitrator, counsel, and legal expert in more than 220 cases involving African, Asian, Canadian, European, Middle Eastern, and US parties. It features in IAP's Africa's 100 Leading Practitioners, was selected the African Personality by Africa Arbitration in June 2018 and by the SIAC in May 2019. He has received the Law Magazine 2017 Best Legal Practitioner Award, the 2018 ASA International Arbitration Advocacy Prize, the 2019 IR Hall of Fame African Arbitrator Award, and the 2020 Client Choice International Award. Also, I learned that he has also won that award in 2021. Most recently, Professor Wahab was selected to feature among the top, there are 64 of them, world-leading arbitration practitioners as part of the Who is Who Legal Global Legal Elite Thought Leaders in Arbitration, and he regularly features in leading directories. Now, Chambers described Prof, the 2021 Chambers, peers regard Mohammed Abdul Wahab as an absolute star in arbitration. Who is Who Legal, the most recent one in 2021, says he's a top-tier thought leader and in a league of his own. Thank you very much, Prof, for agreeing to speak in this session today.
Thank you very much, Abayomi. You set the bar too high for me, but it's a pleasure to be with you today, and Itaya and Madeline and all our colleagues. I'm very grateful. And I'm delighted to be speaking about a topic that is very close to my heart, a topic that we've been preaching for years, and everyone met that with a smile and saying, oh, that's not going to happen. So I'm delighted. Let me start by sharing with you the screen so that you have access to my presentation. Yes, I think you can all see it now. So let me start. My contribution today would be about two things, sort of disambiguating what we mean by ODR and trying to track the field by giving you a walk through the doors, the history, the present, and potentially the future, if I'm not mistaken on certain predictions that I would make. One key word to remember throughout my presentation, and I would venture to say throughout my colleagues as well presentations, and that's indeed important in our field, which is evolution. I think it's important to bear this in mind so that you're prepared to see what's coming your way in this respect. Let me start then by giving you an overview. Let's use an example to prepare you for this discussion. Telephone transformation, that's available online. It's not a slide that I personally put together, but it's interesting. So starting from Graham Bell, 1876, you see there tracking the development of telephones. And I know many of the younger generation would just look at this in museums, but I personally have seen some of these older versions of phones, in fact, at my home and my grandparents' homes in a way, until we reached, of course, the mobile, and then currently the present, whatever sort of we're talking about technology in terms of even now 5G, Android technology, everything in relation to handheld devices. And we think that's the pinnacle of the development and evolution, and it's not. Because the new trend would be basically having like a sort of a very thin, fine bracelet instead of holding a phone, will be on your wrist. And even though R&D show that it's going to be a chip under the skin, you're not going to carry any device. These are part of the research on 3-5 components, where ultimately you're going to have really a phone just there under your skin, nothing more. And may even be evolving to something that we're not yet aware of yet. Anyway, so that's the situation. You see how things change over time. And I think this takes us to the point where we need to track what ODR was about, its past, the present, and the future. So I thought of giving you a brief overview through history. Now, in the 60s up to the 90s, the internet was invented for academic and military purposes. At the time, it was banned from use for commercial purposes. So we have currently seen a shift from a ban on commercial purposes to a fully fledged online platforms of trading on the internet. So it was very interesting, a closed community of academics, military, and then we have the first internet service provider in 1992. Then the World Wide Web was invented. We had Netscape, which many of you may not be aware. And then we had an exponential growth. The latest statistics, as at April 2021, we have about 5.1 billion users connected, almost 53.4% in Asia, which is the largest continent, and about more than 92% of those who have access to the internet, so basically the 5.1 billion users, are connecting to the internet through mobile devices. So pretty much interesting to see the world we're living in and how the internet is sort of progressing at an accelerated pace. Then comes, and I think that's a deserved tribute, in 1996, 27 years after the creation of the internet, the first article on ODR appeared in a law review. And Ethan Katz, whom we call the father of online dispute resolution, wrote an article about dispute resolution in cyberspace. Then they established the virtual magistrate, the online ombudsman office at the University of Massachusetts, and the family disputes ODR project at the University of Maryland. And Ethan published his first ever book on online dispute resolution, introducing the concept of what we call the fourth party, which is technology. In addition to the parties, the third party neutral, and now technology. That was online dispute resolution. And that was the first ever work on ODR. Then 2002 onwards, we see the establishment. You see there, I was a little bit young. We established the online dispute resolution UN Economic Commission for Europe expert group. That was a meeting in Geneva where we established basically the expert group meetings, and they started taking place annually to develop the field of ODR. And then we had a forum every year. Many people may not know, but we had the first ever ODR forum in Africa in 2004. It was hosted in Cairo. I organized it. I brought the concept to the Cairo Center, and we organized, and everyone with an interest in the field of ODR came to Egypt on African soil, and we had the first African ODR forum there in 2004. Colin Rule, of course, published the second book on online dispute resolution for business. You see there, business to business and business to consumers disputes from a practitioner perspective. At the time, he had online dispute resolution platform, and the idea was to track disputes in relation to eBay and other platforms and see how these high volume, low value disputes can be resolved effectively in a non-traditional way. Then in 2012, the third book, which is the ODR, considered the ODR treatise covering all continents and regions. It had ODR and theory, lessons on system design, artificial intelligence, mobiles and ODR, cross-border transactions, and ODR and government, and many others, ODR and culture, but also included a devoted part to tracking ODR in North America, Europe, Australia, Asia, Latin America, and Africa for the first time, writings on ODR. And that was the book that I co-edited with Ethan Katz and Daniel Rainey, and you can see it there. And by the way, this book is freely available online, in fact, now, and we're having a new edition coming out in 2021 on around September. So that is 10 years forward. We are revisiting this, and that will be the second edition. So there are three landmark books in the field of ODR. To just track a little bit this, so the takeaways from there is that between 1990s up until the 2000s, we had a rise in e-commerce dispute. The ban on commercial use of the internet has been lifted. Issues of spam, domain names, IP, things that were happening online did not immediately lend themselves to traditional dispute resolution processes. First of all, in terms of value, they were not high value. Secondly, they were quite fast-paced, so the traditional dispute resolution mechanisms in an offline world was not befitting. So ODR emerged as a possibility for resolving disputes online in cyberspace. At the time, I predicted that it would have a transition and a spillover to the offline world and will be used in offline disputes, but people were not very optimistic about this, and we see now this happening. Suppose this, there have been proliferation of online trading platforms. We see eBay, Alibaba, Amazon, and many others. with the advent of smartphones and ICTs, we now see even now high value and high volume types of disputes. And ODR had to tailor that and then became a field that is capable of evolving and adapting to these disputes. But of course, the focus was on developing dispute systems and preventions as well as resolution. So you're trying to manage disputes, prevent them using online dispute resolution systems like feedback ratings, like trust mark seals, and many others. This has led us, and I say us because there was the group of ODR experts at the time, to write to the United Nations in 2010 to establish an ODR working group. As much as we have the arbitration working group, we have the transport working group, the UN has established working groups for many aspects of the legal field, and we thought that it's time to have an ODR dedicated working group. So 60 or 80 of us, we wrote that and we signed it, and the UNCITRAL established working group 3. Quite a coincidence, working group 3, when it was established, that was for ODR. Now working group 3 is very well known for the work they're doing in relation to investment arbitration, having concluded their work on ODR. Now, following that, there have been over the years, between 2010 and 2016, debates, discussions, meetings about how to develop ODR guidelines, rules, and what the expert group should be doing. And ultimately, as a compromise, they developed technical notes, and we will come to that in a moment. The interesting thing is that we now see a movement from the human third party to the automated fourth party, Ethan Katz referred to earlier, which is technology, and a great move from small data to big data, which we can have a separate presentation on big data and the cloud. But now cloud computing and computer processors that are able to process big data is a fact of life. It's not the future, it's the reality. Now, this brings me to the ODR technical notes so that you're aware and you're able to track the history there. The idea was to develop some rules in relation to cross-border low-value sales or service contracts concluded using e-communications. Now, to assist this, the Organization of American States had already e-commerce initiatives. There was the US on one side, Europe on the other side, and other parts of the world. The compromise situation was to develop these technical notes and to reflect the principles of due process, fairness, transparency, and accountability. They do not promote any practice of ODR as a best practice. They are not binding and are not suitable to be used as rules in terms of any ODR process to apply. But indeed, it has shifted the focus to a special field that is now spawning its own culture, which is ODR, and providing a framework for discussion and technical considerations for those engaged in the field. Now, over the past decade, even following the technical note, we've been fighting to promote ODR to the world. And of course, part of the comfort zone is that people are happy to continue to do what they're doing in the manner they're doing. And there was no incentive, motivation to use ODR schemes for traditional arbitration, let's say, or so. Even though ODR was successful with mediation, and we will hear from Madeline on this. And we have also seen what I call the visible element of ODR, which is remote or virtual hearings, and we will be hearing from Isaiah on this. Now, the interesting thing is that in itself, this visible element of remote hearings, ODR per se, that's what we will see. And I would present to you and submit that it's not, it's one aspect, it's a tool, it's one element, but it's not ODR. But anyway, COVID-19 has accelerated this. This was back in 2010 in Vienna when I presented this, and I said, you know, at the end of the day, it's going to be a necessity very soon. And then COVID accelerated and showed us that the reality is that technology is unavoidable because of the situation that has unfolded. So again, necessity has become a reality, and this is where we stand today. Now, the framework, before we address this for ODR, we group them in three categories: the technological factors, the cultural, and the legal factors. You need all three, which is what I call the ODR triangle, to have a successful ODR process. Technology is indispensable. It's the fourth party. You need to have proper connectivity. And I know that's a little bit of a challenge for Africa, but we're picking up a lot of investments in ICT, infrastructure, and connectivity, as well as matters of cybersecurity. So it is important and unavoidable to have this technological element. Cultural element is indeed important and challenging, because as people transition from a paper society to a paperless society and use technology, there's always trust and confidence issues. But what I can present to you as a fact is, as much as we have challenges and problems with security in hard copies and paper-based documents, it is no different in the online world. The whole idea is that for every sort of use of technology, you have a counter use or abuse in a way, and people have to be vigilant and in fact investing in the developing technologies to create trust and awareness and confidence in this regard. And of course, the legal factors are absolutely important, because without a proper regulatory or legislative framework that acknowledges e-business or e-communications, or give evidential value, or protect intellectual property, or deal with cybercrime, or provide an e-resolution framework for consumers or businesses transacting online, all the efforts would ultimately fail. Judiciaries, courts across the globe would need a legislative framework to work and navigate their way through these online applications. And so again, this is proliferating. So this is, I think, an important framework to keep in mind. And this brings us to the $1 billion question, which is, what is ODR? And I must say here, to take a stand objectively, saying even amongst the group of experts in ICODA, which is the International Council on Online Dispute Resolution, we have a disagreement on the definition of ODR, believe it or not. Almost 20 years later, we cannot agree a definition of ODR. So what you hear now is my own view of it, but not necessarily shared by others. And I will candidly share with you what others believe is the case. So is it a medium? Is it a tool? Is it a process? Do you use it for in-court, out-court? Is it simply using technology to resolve disputes, or what I have classified in one of my articles previously as technology facilitated, technology assisted, and technology based ODR schemes? What is it really? Does it encompass all this? And that's where the sort of disagreement, because many of our colleagues, and they have a very valid point, they say any element of technology used in dispute resolution makes the process ODR. To my own view, that means that we are actually having only ODR processes, because we communicate by emails through traditional arbitration proceedings, traditional mediation proceedings, and others. And this is an element of technology. We use video conferencing, and that's an element of technology. If that is going to be ODR, then this means that there is nothing called ADR, and that all processes we're doing is ODR. So that's the difficulty conceptually that I have with such view of ODR in that sense. And this, to me, what I present to you as a view is that my view of ODR is using state-of-the-art technologies, not just ICTs, but I think as well artificial intelligence, where you have technology is integrated, embedded into the process, so that at least it is wholly or substantially taking place online and resolved online. To me, that gives the fourth party, captured and coined by Ethan Catch, a meaningful impact. It's not just using it as a tool, but as a resolution mechanism. And that's what sets ODR apart in that sense. You may, of course, agree or disagree with that, but this is just an attempt from my side to make this transition or evolutionary step. Remember, the word evolution, I told you, is key. Evolutionary step from ADR to ODR. And ultimately, I will share with you this one of my concluding remarks. I would see that we are going to enter into the realm where ADR could ultimately disappear, and we will have ODR as technology takes over, whether for good or for worse. But the reality is that we see the trajectory that technology is taking over. Now, looking at the spectrum of tools of ODR, I'm not going to address each and every one because of time constraints, but I'm just giving you an idea. You have to understand that the spectrum of ODR is not fully aligned with ADR. So it's not that we have mediation offline, it is done online, arbitration offline, we have it online, negotiation offline, we do it online. ODR has spawned its own culture and set of processes that you do not encounter in an offline environment. And as I mentioned, I group these into three categories. The ODR facilitated online dispute prevention guarantees like trust mark seals, escrows, credit card chargebacks, feedback rating systems, and the ODR or technology assisted ODR schemes. And here we have an overlap with traditional ADR, which is basically arbitration, mediation, negotiation, online ombudsman, but increasingly so predictive justice applications, which are not encountered in the offline world, and e-courts and e-juries. And I think that's a distinctive element between ODR and ADR, because ADR, whether you take it as amicable or alternative, it does not encompass in-court processes. But ODR does encompass in-court processes, and we see that in reality. In fact, there are projects in China and beyond where we have using artificial intelligence and virtual judge to assist disputants with their cases. And this brings me to the final point there, the technology-based mechanisms where we have automated negotiations, advanced artificial intelligence solution set databases, ODR and blockchain, as we see smart contracts and blockchain taking over, and the AI judge that I mentioned, which, by the way, has been used to resolve over 400,000 cases in China during the last year only. And then the fear from everyone in our field, which is robots or robotic mediators and arbitrators taking over. And this is a controversial area in its own, whether we like it or not. But it's, at least we see seeds of it to support processes taking place and a lot of R&D taking place there. I think the human element is important. The displacement of the human element, even though if taking place, I think ultimately we will come around, because despite the elevated level of efficiency that machines or robots or artificial intelligence can bring to processes, the human error element of things may be missed over the years and could be longed for in due course. In terms of parties, ODR is used and is suitable for business to business, business to consumers, consumer to consumer, which we see in the online marketplace, government to government, government to business, and government to consumers. And we see now as well, many government applications are offered online, including complaint systems, complaint handling. And this is one aspect on the spectrum of ODR. Moving forward quickly, iCoder, just to give you an idea, these are the members of the iCoder, those who establish the field and continue there as well. It's a non-profit consortium. Think of it as an equivalent of ICA, but in relation to online dispute resolution. The idea, that's not, by the way, an institution that settles disputes. It simply sets standards, open standards for ODR. That was created in 2017, following our annual forum which took place at the time in Paris, and of course promotes access, use, and public understanding and education of ODR, open to ODR practitioners, setting standards, mentoring professionals, and providing best practices for ODR programs. And it includes people from various interests and fields, not just arbitration, not just mediation, people even who are engineers and have nothing to do specifically with the law. We've developed a number of guidelines regarding the use of video arbitration guidelines or mediation guidelines. And of course, those of you would be familiar with the African Arbitration Academy on virtual arbitration hearings, which is an excellent protocol there. But I could have provided some standards and principles there. Also payment best practices using ODR, as well as payment ODR standards. So these you can have a look online for on the iCoder website. This brings me to a little bit of my concluding remarks, and I believe I'm hoping to be on time with that. Artificial intelligence. We have moved a long way from ICT. Think of it as technology in its passive form, which is using communication, information technology as a medium of communication. And now we have artificial intelligence, which is cutting across all fields and sectors in business and in disputes. Maybe a little bit scary with where are we going to end up with artificial intelligence, but certainly a reality. And we see a lot of investments. And now, instead of just investing in AI in business to generate profits, revenues, people have now, post-COVID, shifted their interest to investing in AI in IA, which is international arbitration. And we see that with the predictive justice applications that are taking place. Now, we see now the use of artificial neural networks in a way. And now we see, as I mentioned, the artificial intelligence judge, the pilot project. Now, I know people are contrasting the human with the robot. My view of things is that with the development of artificial neural networks and investments in AI, it's not going to be humans versus robots in terms of use. It's going to be an artificially infused applications, so that we will see that possibly humans could be injected with chips that will help them. Think of it in a science fiction movie as the cyborgs, where they could have heightened abilities and skills in a way to process applications. I know this is a little bit scary and still medically under examination, but what I can tell you, the fact is, this is being tested to give humans heightened abilities. And we see that in normal medical applications where people who have lost their limbs are given artificial limbs, are given artificial organs to even be better performers compared to their natural sort of organs. Again, scary, but again, we see research and development in the area. Imagination is key, and nonlinear creativity is an aspect that we see in relation to the use of artificial intelligence and ODR. So no matter how hard we try to track the trajectory of the use of either information technology or artificial intelligence in dispute resolution, the limit is really our imagination and creativity. And Einstein himself, who's of course a well-known scientist, says that imagination is more important than knowledge. And this is, to an extent, how he reached a lot of the ways of science and predictions that he have done and the equations that he successfully developed. So anyway, I think the best way to predict the future is to invent it. We have to be careful how we invent it, as Alan Kay has mentioned. And this brings me to the few last slides, actually my last one before I leave you, which is ODR was traditionally perceived as the simple use of technology in the broadest sense. We are way beyond this. It's not just ADR online, it is integrated in court, out of court, and is, in fact, we see the fourth party technology taking over from the third party. Instead of assisting and supporting, it's taking over for dispute prevention, management, and resolution. AI applications will become normative in dispute avoidance, management, and resolution. And I now leave you with few predictions, one of which I mentioned and alluded to, which is chips being inserted in humans. I'm not sure I would want to live that age, but it's coming our way. We have to be careful that we use technology prudently and wisely. And this Who knows that? Believe it or not, I would not be surprised if many of you would not know it, but that is a handheld lie detector. Imagine witnesses entering arbitration hearings and now subjected to a lie detector test rather than an oath. What would that mean? And where would that leave us with witness testimony, for example? And what happens if we apply it to counsel? What happens if we apply it across the board to others? It's a very serious development. Whether people want to integrate that, I'm not advocating for it, but it's an interesting development. It's no longer the big machine in the room connected. It's a portable device that detects this. Holographic visual projections, assuming that humans will not be able to travel from one place to the other at the speed of light and time. Again, not sure that I want to live that era, but holographic visual projections. It's not going to be a two-dimensional thing in virtual or remote hearings. We are going to see holographic visual projections. That's not a prediction, that's a reality. Those who visit airports now would see holographic visual projections as information points of people giving them instructions and information. With that, I thank you. I went a little bit about 4 or 5 minutes over my time. I hope that's fine. But I think it leaves us with a lot to think about. But there you go. It's a field that is taking over the ADR field and exceedingly important. The final point I make is that with COVID, apparently everyone across the globe is presenting themselves as an ODR expert. So we will have to see how the situation unfolds, and I'm very much looking forward to the excellent presentations of Isaiah and Madeline, and thank you very much for your time and for listening.
Thank you very much, Prof, for that very, very insightful presentation. One thing that just jumped out, Prof, you said that ODR will in the future take over from ADR. You also advocate for the use of artificial intelligence. The question, because most of our attendees are Africa-based, they're in Africa. The question is, how far behind are we in Africa, and how do we sidestep, or how do we catch up? Can we even catch up? And how do we sidestep all the concerns or challenges? Because you spoke about e-courts. I don't know how many of the jurisdictions in Africa, are already doing that. Just a question for you before I move to Madeline.
Absolutely. Do you want me to answer that now?
Well, before to answer now, and I can also move to Madeline and come back to you.
Sure, whatever you prefer. Let me know.
Okay. Maybe I should take that later. Let me move to Madeline. Madeline, let me do a quick introduction. Madeline is my very good friend, and she's the founder of iResolve Limited, a boutique corporate arbitration and dispute resolution firm in Tanzania. She's practicing commercial and corporate law and has acted as counsel, party appointed arbitrator, commercial mediator, and arbitral secretary in both domestic and international arbitrations. She's the current president of the Tanzania Institute of Arbitrators and chairperson of the Africa-Asia Mediation Association. She currently serves as a member of the ICC International Court of Arbitration, representing Tanzania. She's a member of the ICC African Commission, the ICC Commission on Arbitration and ADR. She was recently appointed as a member of the IBA Africa Arbitration Network, and she's a member of the Pledge Africa Subcommittee. In 2019, she was awarded Top 50 Women in Management Award in Tanzania, and also awarded Top 50 Most Promising Young Arbitration Practitioner in 2020. Madeline is a renowned Africa-based industry futurist, adopting legal tech solutions, which she does with highly regarded iResolve, an ODR system launched in 2015, aimed at realizing her ambition to provide innovative delivery of legal solutions. And one remarkable thing about her, she once described the next generation as smart dispute resolvers. And Madeline routinely offers tailored trainings under the ILI Washington on ODR, online mediation, and virtual arbitration practical courses to various institutions. Thank you very much, Madeline, for agreeing to speak. You may now have the floor.
Thank you, Abayomi. Thank you for that very well articulated, or maybe very comprehensive introduction. Thank you so much. I'm privileged and grateful to have the opportunity to present today among the distinguished panel that I'm presenting with. I had, I think it was not chance, but it was by fate, a meeting Professor Wahab sometime back in 2018, if I recall correctly. And that really just, you know, with the ODR work that I had been starting to do, that really just sort of triggered a lot of energy for me to spearhead this in my country, and of course network out as best as I can on the African continent. So, you know, to what Professor has said to our participants is that imagination is the highest form of research, and this is what Albert Einstein stated. And I think I second that, and I fully accept the fact that it is only the imagination that would then take us that way forward in terms of invention. Now, what came about to me establishing an online dispute resolution? I'd like to start off with that first before going on to my presentation. Now, sometime back in 2014, I started my corporate law firm. It's a boutique firm, and I saw the need, having had transitioned from the banking industry, which is heavily tech driven, to a corporate self-standing law firm. I felt the need to include technology in the service stream to afford my clients that ease of access to the solutions that could be at the touch of your hand. As Professor explained, it really is a myriad of options that you have when you're using ICTs. Now, he's gone on and sort of explored that it's not only ICTs, but there are also these technologies that are evolving over time, which have evolved over time and are currently being utilized in various formats or in various sections of our dispute resolution systems. And that those technologies can be utilized not only by individual parties, but she's gone through the processes, through the spectrum of users, meaning B2B, B2C, G2G, and so on and so forth. And so that evolution is ongoing, but as he had put forward, it's been catalyzed by the pandemic. It's really just, we've leapfrogged from probably the mark of 30% usage to about 80% usage of technology in delivering our services, not only for me speaking as a lawyer in my legal work, but also as a dispute resolver. This is what we have seen. Litigants have had to take in e-filing formats from the courts, establishment of e-filing rules. We've had to appear before a judge via a virtual court system. And so these changes have not only forced us now to become tech savvy, but also forced us to understand how do we then apply these technologies in our day-to-day businesses. And as SMEs, this comes in at a very important time, and this training is very crucial for your business to prosper in terms of dispute prevention, in terms of dispute management, in terms of avoiding disputes or minimizing the exposure that your business could have by utilizing these resources, which are really tech-driven resources. Now, I'll project my screen so that I am in time when it comes to sharing my screen. Hopefully that can be seen. And I hope you can see the screen in front of you with the first presentation slide. Can you confirm, Abayomi?
Yes, we can. It's
Okay.
right.
Now, as I say, iResolve initially started as a matter of a management tool. It has evolved over time, and it has incorporated other mechanisms or handling in terms of what the end user had requested. And so it was really reacting to the end user's needs. And so it started off as a management tool in terms of matter management. And then we developed closed chat rooms, which were then used more of a static form of communication. And these are now the past methods. If we look at what has happened, that was phase one. And then in phase two, we saw the need to incorporate not only payment methods, in collecting the neutrals payments, but also video conferencing facilities. Those have proved very difficult to incorporate into one system. And so some may need to drop off in order to use a third-party provider, as you would see later in my presentation. Now, just to kick off, I start off with Colin Rule, and I like starting off with this because it really just gets you to reflect and as Professor said, evolution, the process of change. What he said in the 2000s, just at the turn of the millennium, was that we see a bright future for ODR, a future which the value of ODR to all is so obvious that we will one day say, what took us so long? And I think this is the question in everyone's mind at this point in time. What took us so long? Did it have to be a pandemic that gets us to react in the manner that we have reacted by embracing technology to the levels that we have embraced technology? I think it did. And so that is proof in it all that we were very hesitant. And as you may recall from Professor's presentation, he said that when they started talking about this in the 90s, everyone would just smile and just nod their head and say, oh, okay, then we'll wait to see that. But then we've seen it happen. So ODR is not a new mode of dispute resolution. As presented earlier, it's using ICTs with the ADR mechanisms that we all know of. So there is no change to the ADR mechanisms that we are aware of. And we'll look at these in the spectrum, such as mediation, arbitration, and includes the hybrid processes that are contained in that ADR spectrum that we might be aware of, those who are participating. It is now the introduction of this fourth party, which is the state-of-the-art technology, or ICT, to either facilitate and assist the parties in the process, or as we've seen in the presentation, be actually incorporated fully into that dispute resolution process, such as the automated e-courts or blind bidding sort of processes or systems, which are really just automated and heavily supported by artificial intelligence. Now, for SMEs, and it was difficult today for me to prepare for my presentation, because for SMEs, we naturally know that disputes may arise across borders between SMEs, and businesses are more familiar with the traditional arbitration or the traditional methods of resolving their disputes through the court systems, or the traditional arbitration in terms of face-to-face arbitration. But with technology, it can enable SMEs with the right procedures being adapted, of course, to heavily cost cut the entire process of resolving the disputes that may arise within that space, the SME space. Now, for example, providing that there is one arbitrator instead of three, or providing that the kind of disputes that would be going for physical meetings as opposed to virtual meetings. All these are thoughts that SME owners, SME managements should think of. What kind of disputes should we channel through the traditional means if at all, they are not arbitrable, for example, or are not accepted in our legal environment, because as presented earlier, the enabling environment is really the national laws in which you operate. And if the national laws do not accommodate for e-processes in terms of maybe the Evidence Act, or having ICT laws that are advanced and in line with the UNICITRAL electronic commerce model law, then that would sort of maybe push you a little bit back. But processes may be adapted if you have a well thought out strategy in terms of your dispute resolution policy within your internal management systems. And that would be one key advice for SMEs when adapting or trying to transition into now utilizing remote ADR or ODR mechanisms. Now, what I have there in front of you is the ODR spectrum. And that's really outlining what I've just been speaking about in terms of the ODR being really just a mirroring of the ADR that we are all aware of in terms of the traditional formats, in traditional mechanisms that we are conversant about. Now, in terms of online, we've seen that ADR transitions to use of ICTs, or of course, state-of-the-art technologies, including AIs and supportive, other supportive technologies. And it could be online arbitration, online mediation. Of course, my spectrum has limited it, but it really could cover the whole range, including e-juries, e-courts, and the likes. In my, and just before I move to the next slide, I think it's important to also speak about the fact that, yes, we have evolved, and due to this catalytic effect of the pandemic, we have leapfrogged. Now, if you look at the technical notes, which the professor has referred to, now those technical notes could be very outdated at this point in time because of that speed that we've had to deal with over the past 18 months. And if you look at the technical notes, which are the UNICITRAL technical notes of 2017, yes, they were worked on during a period where we were seeing sort of a turtle-like, or very small, a small speed move towards entire integration of ODR into our ADR mechanisms. It was a slow movement. Now, with this kind of position that we're in terms of online dispute resolution at this stage, when we're presenting to you, we really need to go back to those UNICITRAL technical notes and maybe reach out to the UN and say, okay, well, these were the classical approaches. These were the initial sort of past references. Now, what do we have to do? Of course, it's a non-binding document, as pointed out earlier, but they need to be reformulated in order now to take advantage of the fact now that we have arbitration that is for example, what I wanted to refer to was blockchain arbitration. Sorry, the word had sort of flown off there. Blockchain arbitration, automated online dispute resolution mechanisms that were probably not thought of at that time. We've got this cryptocurrencies also being implemented in not only in the African continent, but elsewhere. We've seen this already, a booming need for cryptocurrencies, and there's several ones that are available. And so these have really pushed back the UNICITRAL notes to being slightly antiquated at this point in time. And that's just a point I wanted to make on the UNICITRAL technical notes. Now, with the spectrum that we were looking at, you could consider several factors: the relationship of the parties, the time being of essence, the goal being that you want to resolve cost effectively, And of course, the geographical elements or limitations and restrictions that could be privy to your particular dispute. And then, of course, the kind of documentation. And so these are considerations when you're considering shifting from the traditional to the now online sort of remote process, which is ODR. Now, online dispute resolution, as presented, could be through different methods. We've spoken about emails, we've spoken about closed chats, video conferencing, and that's really just one of those elements that could be the driving factor behind the ODR system in use. Sometimes in the experience of iResolve, what we find is that there's the need for a combination of the two. And why a combination of the two? It really does go back to the essence of ODR being the top of the pyramid, or the top requirement being the trust issue. And with ODR providers such as iResolve, the building trust and having the end user trust the system is one of critical importance for you to be able to say that users have that comfort that their data or the levels of security that is required for their data to be protected. Now, including trust seals, including other certifications that could provide that comfort or build that trust among the end users. And when I speak of the end users, it is you, the SMEs, or the ADR providers and practitioners, ADR practitioners who are using the ODR platform to perform the particular mechanism on an ICT-based or on a technology-based platform. In my next slide, I thought of having to also emphasize on the two types of ODR. And in many writings, and if you read the books referred to by Dr. Wahab, Professor Wahab, they really are very comprehensive when they're touching on the synchronous and asynchronous methods, whereby the synchronous methods communication is all about the communication being used for the resolution of that disputes. Online parties, however, have the possibility of maybe using both, as I said earlier, both discussion forums, for example, emails and testing. And this was traditionally what we witnessed. Arbitrators would get their appointments through email. They would be able to drive the process by email and only meet the parties when they call upon, for example, the preliminary meeting and of course the hearing. But all the while over the past, we have seen the use of both these methods, and it is really not a new breed. Now, on the ODR process map, being that I'm speaking as an ODR provider, I find it useful to also make you aware of the process. So each ODR provider would have their own processes, and not only their own processes, but they would have their own terms and conditions attached to those processes. And so if you're going to be utilizing these ODR platforms, that particular background research, the same way that you would do when either instituting a mediation or an arbitration at a particular center, then this is the same kind of research that I would advise ADR practitioners to do. And SMEs in implementing your dispute resolution processes, your internal dispute resolution processes or external dispute resolution processes, that you'd have to consider which providers best suit the kind of disputes that are generated from your kind of business. I think this is a very important question for those SMEs that are available here today for this particular webinar. Now, what you can see there is just the process map where you have from the lodging of the dispute or the claim. And I find that the ODR providers are more prone to the small claims, and not only the small claims, but also the consumer-based disputes that are usually sort of government to consumer or business to consumer based disputes, and they work well in that manner because of that element of being mandatory, maybe are provided for by a particular statute. And so they tend to pick up more if an ODR provider is attached to a particular government organization or a business that is required by statute to provide consumer dispute resolution access to their consumers. And then once you've lodged your dispute, you of course go by the rules of that ODR provider. If they have particular rules of procedure, then they would probably, for iResolve, what we do is appoint a particular ADR specialist who would then assess whether this is a mediation or does it channel through to the arbitration or any other form of ADR. And then a respondent would then be notified, and that notification is usually by email. And so when you're lodging, that particular format would require you to enter the details of the respondent. And with that, then the respondent would either respond, and most of the times they would not respond because they would wonder, what is this? What is this iResolve? They'll probably give it a little bit of a hard time until they do end up either showing up near to the end, or at least sending in their personal physically. This is what we've experienced before, but with the pandemic, we find that there's a more positive acceptance. Then the filing of the position statements, if it's mediation, or the pleadings, can be done on that ODR platform if it provides for such storage. Some ODR providers don't have the storage or for storing the exchange of pleadings or the exchanged pleadings and documentary evidence. But there are third-party providers that could be integrated into that process by the parties. Now, oral hearings, or as we will hear more about them for arbitration from Isaiah, those then would follow in a mediation. It would be a mediation session where you actually meet with the mediator in an online environment or physical. Now, if they opt for physical, then the parties really would then meet physically in the process that we have. But if it isn't a fully implemented online dispute resolution process, then that would be conducted virtually. Then we get to the settlement and the decision, or if it's an adjudication, and then their final award in terms of an arbitration procedure. This is the vision that an ODR platform would really look like if you look at it in terms of picture. Now, you'd see that we've put an ODR administrator who is also provided for under Technical Notes 27 of the UNICITRAL Technical Notes on ODR. And with the notes, it describes an ODR administrator to be an entity that carries out such administration and coordination of that particular process. And with an ODR platform, there should be that administered or coordinated function, and either embedded in the system or may be a separate from that particular platform. And so that really depends on the platform that you would be using. Now, the technical notes go further also to elaborate on the different roles of the platform and the administrator. Of course, the platform itself, as I said earlier, and you can see there on the slide, is a system for generating, sending, receiving, storing, exchanging, or otherwise processing the communications in a manner that ensures data security. And that's the wording of the Technical Note 26. Now, we move on to looking at much more length online mediation. And online mediation has been defined by several literatures. And I haven't come across one that really fits online mediation. So I've put several bullet points in front of you. And the first one goes, it is a system-based as opposed to a face-to-face based mechanism in which an impartial third party called the mediator facilitates the negotiation process between two or more people. Then it goes on to say in the bullet that follows is, it is supported by the internet, whole process versus parts of the process. Different types of e-mediation then would fall in there. And then you go on to the third bullet, and it says there that the use of general, so this is telephone, so this is the past, you know, if we're speaking on what the presentation just took place, this is the past where we're using telephones, faxes, you know, our PCs, email exchanges, but now there is that video conferencing, there's AI and the rest, enhancing the use of the AI enhances the use of that technology. Then, and for unspecified, it says that unspecified limited electronic technology, or it is a cloud-based environment. Now, what the statement that is bolded there in red says is that it strongly resembles offline counterparts, and that's why mediation, online mediation, is often really seen to have taken more accommodated more electronic means because it really it doesn't have those procedural aspects of an arbitration, for example. And this is, as you can see, there's a flexibility in terms of driving the process in an online environment, and the possibilities there then make it much more easier to adapt or mirror it in a technology-based mean. Some examples we've seen in the past presentation, and these are automated software programs. You know, there's One Accord, Web Mediate, Internet Neutral, BBB Online. These are past automated software programs. Some, of course, still in place. We've spoken about the closed chat rooms and the virtual versions of meeting rooms. These are really virtual versions of meeting rooms, but really it is more static as opposed to the video conferencing, where you see a projection of who you are you're conversating with. Now, the electronic tools also, if we read Bellucci and Zeleknov, if I say the name correctly, the electronic tools enable increased flexibility because virtual mediation sometimes becomes electronic mediation, negotiation, and vice versa. Mediation is a facilitated negotiation, and so those tools that could be utilized in terms of facilitating that negotiation could be applied by way either synchronous or asynchronous means. Now, in a mediation, one could consider these issues. There's less control over physical environment. There's reliance on the technology, and then, of course, there's no control over the participants' environment. So you're unable to control the environment as where if you were in an offline environment where you're meeting in a room. For example, for mediators, we find it very difficult to build that rapport initially because in an online environment, building rapport is slightly more complex as opposed to having those who are mediating in front of you come to your chambers for a mediation where you could build rapport immediately upon them entering the room by just a mere way of how you invite them into that room. But in an online environment, you would have to adapt a different skill set, and that skill set that to build rapport is really depending on the mediator. Some mediators prefer having initial preliminary meetings to just know the parties, understand the technology, and build confidence in the use of that technology. Now, moving on to e-arbitration or online arbitration. And virtual or remote hearings, it would be very different if, as you can see in this particular diagram, where you have different definitions, where if you speak of remote, this is using the technology which allows two or more locations to interact simultaneously by two-way video and audio transmission, facilitating the communication and the personal interaction between those two locations those persons are seated. And this is directly from the Hague Conference on Private International Law guide to good practice on the use of video link under the Evidence Convention 2020. This is how they describe remote, the word remote hearing. Then when you move on to the virtual hearing, and that's why we have to differentiate what do we mean by ODR? And we can't all align in terms of what is ODR. If you go back to virtual, it's telling you there, if you look at the Oxford dictionaries, that not physically present as such, but made by software to appear to be so from the point of view of a program or user. That would then get you to rethink that virtuality of that particular proceeding. Then you've got your semi-remote hearings, which we will touch on, is that one side or its witnesses or the experts participates remotely, but the others do not. And this does happen, especially in international arbitration, where it is really the parties are positioned in different ends of the world. Now, online hearings, we've been hearing about online hearings. It's an overlap with ODR and online courts, hence could be also slightly confusing. For example, online court, the virtual hearing is a court hearing conducted by audio-visual means, meaning the virtual court system, where cases are sort of processed without the need for participants to attend court in person. And that's from the Supreme Court of Victoria in Australia, 2020. So that's where they define, how they define online courts. Slightly different from the ODR that we are speaking about. Now, when you're strategizing to moving remotely from the traditional, and I think the speaker that follows will speak more when it comes to remote arbitration. When you're strategizing for ADR in general to move to virtual, you would need to take into account some of these itemized items on this bullet, on this particular slide. The parties' right to equal treatment and, of course, the right to be heard if it's an arbitration, identifying the issues, eliminating oral hearings if it's possible, and that really does take us to my next slide, which is about documents-only arbitration, limiting the written submissions between the parties, and limiting oral hearings. I think that's also replicating the bullet point before that, limiting the evidence being produced by the parties, and of course having that innovative option available for the participants in that dispute resolution process. Eliminating oral hearings could be done by agreement of the parties, and if no agreement, then that also could be decided upon in terms of a tribunal, by the tribunal if it's an arbitration. Limiting the written submissions, that could be challenging, but it's doable in your, as an arbitrator, for example. What we would do is we would advise parties to limit maybe submissions to a couple of pages, as opposed to having to go their way in submitting heavy submissions. Innovating options, having that flexibility to accept the use of technologies available. In a documents-only arbitration, and this is an option to parties who are conducting, who are in an arbitral proceedings, they may opt to agree for their disputes to be decided upon without oral hearing. And the benefits of that, as presented in that slide, is that there will be these would be low to medium value disputes, and this would cut the costs and maintain that cost cutting effect in terms of now applying a documents only arbitration. Of course, the parties would rely only on the written submissions, and they would not have any hearing. That's the downfall for that. And some national laws and arbitration rules could also provide for how this could be implemented well. Some guides are also available, especially the Chartered Institute of Arbitrators guidelines on documents-only arbitration procedures. I think that's a very good go-to document if you're going to adapt a documents-only arbitration. And I think a documents-only arbitration works well for an SME kind of related dispute. What I find is that the disputes usually maybe not heavy big data sort of kind of disputes and not very complex. But if it is complex disputes, then you find that the arbitrator at some point may need to have maybe that oral hearing conducted in order for them to get the grip of what is the underlying dispute, or what is the underlying complexity that they are unable to understand. Just to get clarification, they may order for an oral hearing, and of course the parties would have to agree to that. Now, one good example is the domain dispute resolution process under the WIPO Mediation and Arbitration Center. I think this has really solidified the way of which documents only adjudicative or arbitration process could work very well. And that, of course, is under the ICANN structure of domain dispute resolution policy, the UNDRP. And so that is a good example of why a documents only arbitration could be successful for the kind of dispute that we would find would be much more accommodative of that kind of structure. Now, avoiding challenges, and I know that the next speaker would speak more on party participation and the party's consent, but I would like to highlight also some cases that are touching on the right to be heard. So in an arbitration, for example, parties, the key underlying principle there of right to be heard has to be observed. And there's some courts have held that there would be no breach of the Article 5 of the 1B of the New York Convention. Remote hearings in and of themselves are no issue under the particular article in another case. And so as long as parties are being provided with that room and opportunity, then there will be less chances of having an arbitral award challenged in the court of law. Then we move on to the next bullet, which is the right to be treated equally. Now, this is also an issue which could raise challenges in terms of arbitrations now. And in an online environment, the same levels of applicability of the right to be treated equally would need to be observed as in the traditional forms of ADR, of arbitration. And so inequality in technology means what the SOL protocol, and this is a protocol on virtual hearings that is available online, is that the tribunal may terminate the video conference at any time if the tribunal deems the video conference to so unsatisfactory that it is unfair to either party to continue. And so this comes about maybe usually at the point where you have a participant who's unable to use the technology and you proceed on using technology despite that fact. And so that could amount to inequality. And then the restrictions on travel, of course, they could adapt the semi-virtual, some in person, others remotely. And there's a good guidance provided for under the Chartered Institute of Arbitrators guidance notes on remote proceedings that was produced in 2020. And that note goes on to say that in the interest of equality, it is preferable that if one party must appear to the tribunal remotely, both parties should do so. Now, just preliminary considerations, and I hope I still have some time to go through the preliminary considerations when now you're shifting from the traditional to the remote applicability of that ADR mechanism. You have to select the technology, and cost is one issue for one to consider. Most of the essentials of a virtual arbitration can be fulfilled by free versions, but free versions won't allow you to do a lot. It will just give you the basic features. And so selecting the technology is very important because there's the cost element, and that cost element either has to be borne by the parties equally or as agreed. And so the practical considerations would then be next, whereby the participants' technical abilities, as I said earlier, the data security and confidentiality, the technology efficiencies, where we spoke of the ICT's infrastructures in Africa, picking up speed in terms of becoming more effective, but there's still interruption, there's still low quality internet that would hinder a participant in that particular arbitration or mediation to efficiently take part. Then there's the breakout rooms and the need to subgroup some of the members, maybe from experts to the arbitrators themselves, having their own breakout room for deliberation. All these are technology efficiencies that one would need to consider having in that technology that they select. And of course, the cost element, as indicated prior. The technical disruptions, that is something that we have seen happen a lot of times. We've even seen the same happen in just a mere webinar. And so having a backup plan is highly encouraged. And those backup plans are evidenced even in the several protocols and models or guidance notes that have been issued by several organizations, including the Africa AAA protocol. The logistics and the preparatory arrangements, of course, these are heavy works when it comes to the online remotely driven dispute resolution mechanisms, because you have to prepare. You have to be you have to have tested the platform. You have to be ready to use or utilize large or multiple screens, and being able to navigate through the softwares and the hardware that is in front of you. And so it is difficult work, not only for the neutral, but also for the participants who are the parties and their representatives. And so being aware, having those arrangements being made in advance is critical. And I wouldn't go over each item of this particular slide. Now, preparing for remoteness, in conclusion, is considering the nature of that dispute, having the parties participating, having the same levels of know-how in using that technology is very important. Having that informed participation and secured party consent is of critical importance. And of course, checking and ensuring that the particular dispute at hand, the particular governing law that is applicable enables you to utilize remote means of resolving your disputes. Of course, at this point in time, national laws have advanced over the couple of years, and they do allow for electronic transactions, they do allow for electronic evidence, and so we don't face a lot of challenge in terms of that. But each jurisdiction would have its own issues. Consider the institutional rules if you're going to have institutional rules applicable, or utilize maybe the rules of the ADR provider, because the ADR provider could have rules that could be sufficient for your cause. And then, of course, having a tech-savvy neutral. When you're electing or selecting your neutral, ensure that the neutral is able to adapt to the technology. And of course, as a last point there, is that in any process that goes remotely, it is very helpful to adapt either a protocol or a guide that could assist in the process, especially when you are encountering a problem in using technology to assist in terms of resolving your disputes. And I think that's where I end with my presentation, and I hope I have been able to advise the SMEs and the ADR practitioners in terms of utilizing ODR in resolving their disputes. Thank you.
Thank you very much, Madeline, for those useful insights. I have one question for you in the Q&A box from one of the attendees, but I'll quickly go to Isaiah for his intervention before we now come back to those questions. And Isaiah is another good friend of mine, very good friend of mine. I'll just quickly read his bio. He's a partner at Bozimo and Company, a practice specializing in arbitration and dispute resolution in Abuja. Isaiah's reputation for delivering high-value settlement and victories has earned him recognition as one of the rising stars on the African continent. He has represented state-owned entities, corporations, and high-net-worth individuals in several ad hoc and institutional arbitrations. Isaiah has also served as sole arbitrator and co-arbitrator under the rules of the ICC, LCA, and OCTRA. Isaiah previously served as a representative of the ICC, YAF, that's for Africa, Middle East, and Turkey. He has provided strategic guidance and mentorship through free workshops for young African legal practitioners. In addition to being a member of the ICC and fellow of Prime Disputes, his leadership qualities has earned him an appointment on the drafting committee for Nigeria's Arbitration and Mediation Bill. Isaiah has been recognized as one of the 50 most promising arbitration practitioners in Africa, and the Who is Who Liga has been featured in by the Who is Who Liga 2020 and the 2021 as a future leader in arbitration. Thank you very much, Isaiah, for agreeing to speak. You may take it from now.
Abayomi, thank you very much indeed. Good afternoon to everyone joining us. And I've enjoyed the presentation so far, particularly Professor's reference to computer chips being implanted in human beings. And if you've had the pleasure of speaking with Professor Wahab, you would only but wonder whether he's an early adopter of that process of being technologically enhanced. He is a man of vast knowledge, and I hope each and every one of you will have the opportunity of speaking with him one-on-one at some point. Well, onto the discussions. So I will be speaking specifically on points you should consider when organizing remote proceedings, specifically arbitration proceedings. And we've heard a very good sort of framework from Prof regarding how ODR has evolved, and from Madeline as well, taking us through some of the platforms and some of the points you would consider, and you would find that some of my talking points overlap. So I won't spend as much time on those. And in making these discussions, I want it to be as engaging and as interactive as possible. So from time to time, I'll come to you with certain questions. Please don't be shy. If the spirit moves you, then just throw an answer in the chat. It will be interesting to see how you're thinking about these issues and how you think some of the difficulties or some of the more practical problems might be resolved. So moving on, as to an overview, Professor Wahab in his presentation gave a framework, and I think my overview sort of mirrors that framework. So we'll be talking about legal considerations in organizing virtual proceedings. Can you even do it? Are you legally permitted to do it? To the extent that you are, then what are the technological considerations that you should be thinking about? And more importantly, what are the practical considerations you should be thinking about? I find that the practical considerations are the ones that are not discussed as much, and hopefully we will sort of share some insights as to what to do in a particularly given situation. Now, can you do it? Legally speaking, can you do it? Well, the first place you might want to look at is the parties' agreement, which, as you all know, forms the foundation for the tribunal's jurisdiction. Now, if the parties have not agreed to virtual proceedings and you proceed, then you run the risk of your award being set aside. So I've given the example here of Article 34 to A4 of the Ancestral Model Law, which allows a court to set aside an award if it was not in accordance with the parties' agreement. So invariably, you will find that most, if not all, arbitration agreements do not envisage virtual proceedings. So let's have a look at the first scenario. If the parties agree, should the arbitrator proceed remotely? Just throw an answer in the chat. I'm just interested in seeing what you think. Let's assume that your arbitration clause says we can proceed remotely if the need arises. In that scenario, should the arbitrators proceed? I'll give you a moment. Just throw an answer in the chat, and please don't be shy. So while we're waiting, let's have a look. Well, usually the arbitrators will defer to the parties' agreement, but you need to be mindful of the fact that notwithstanding the parties' agreement, if there is a mandatory provision in the lex arbitri, then it may not be safe to proceed. So if there is an express prohibition on remote proceedings, then notwithstanding the parties' agreement, it would be unwise to proceed. That said, most arbitration laws and most arbitration rules do not contain an express ban, but you may find a situation where the rules instead refer to an in-person hearing. Now, should you proceed in those circumstances? You probably could if you secure the parties' express agreement that notwithstanding that provision, you can proceed remotely. Now, let's look at the other situation. If one of the parties objects, should the tribunal proceed remotely? Thank you very much, Idrisu, for your answer for the first one. So what do you think for this scenario? If one of the parties says, I do not want to proceed remotely, and one says, I would like to, should the tribunal proceed in this circumstance? Again, I'll give you a moment. Just no. Prince Benjamin says, no, absolutely not. Well, as with all things in this circle, it depends. And I say this very carefully, but it really does depend. It depends on the reason for me. You have to look at it on a case-by-case scenario. So the first thing I want to look at is, does the lex arbitri allow remote proceedings? And as we saw before, most of them might not expressly say so. So you need to see whether the rules are flexible enough to give the tribunal discretion to proceed remotely. So that's the first thing I'm looking at. Now, the second thing I'm looking at is, will proceeding remotely affect a party's ability to present its case? If it does, then there are due process problems and you should not proceed remotely. Now, let me give an example of a situation we encountered in one of the first remote proceedings I was involved in, and I was involved in it as a sole arbitrator. Again, thank you for the answers, Idrissa. You're saying it depends on the other party's concerns. I agree with you entirely. Now, the situation we had there was that funny enough, the respondents sent an application to proceed remotely, and the claimant objected without necessarily stating the reasons for the objection. So the response from us was that, well, could you please articulate the reasons for your not wishing to proceed remotely? And then claimant's counsel came back to say, well, we've incurred costs for travel, costs for hotels, we've prepped all our witnesses, we've made so preparations. So we went back to say, well, are these costs things that a tribunal could possibly remediate with a cost order? And are there any due process concerns you have with proceeding virtually? If you do have any, please articulate them. And at that stage, counsel sort of picked up on the tribunal's hint to say, well, we could probably recover our costs at the appropriate stage, and we do not actually have any due process concerns with proceeding remotely. But these are the things you want to be looking out for. Will proceeding remotely affect a party's ability to present their case? And you also have to juxtapose it with the tribunal's obligation to proceed in an efficient manner, both cost and time efficiency. So let's now presume that you've identified the legal landscape and there is nothing to prevent you from proceeding remotely. Okay, so next thing we need to think about is, well, what technology should we deploy to facilitate these remote proceedings? So there are a number of things to consider, and Madeline pointed out some of them. But in an ideal setup, right, you would want to see all the participants. And again, I'll throw in a story here as to why this is important. There was proceedings, this time we were involved as counsel. And prior to the first procedural meeting, which was also conducted virtually, we had agreed to submit a list of all participants. But at the hearing proper, there were several people in the hearing room who had not been identified. So there was a problem with the arbitrator saying, well, I can't proceed unless I know who these participants are. And some of them had their cameras off and didn't have names on the screens that corresponded with the names submitted to the tribunal. So sometimes if you're on a Zoom call, right, you'll see a participant who joins and their name is iPhone or A22 or something similar. So you need a platform where you'll be able to see all the participants. Something else you need to think about is some platforms, at least some that I've encountered, have a limit as to the number of people it will accommodate. So for instance, I've seen a platform where there were only a maximum number of 6 participants could be on the screen at any given time. So again, if you're going to have quite a large arbitration, that's something you'll need to consider. Then the next thing you need to consider is the tech has to enable this, and you've heard it before, this synchronous communication between the parties. We need to be able to hear each person as they speak. And also if any interpretation requirements are, if any interpretation is required, then does the platform accommodate that as well? Can you have an interpretation channel? You also need to be able to see all the documents being projected on the screen, as well as have access to those copies. So again, does the platform allow electronic presentation of evidence? And sometimes you will also need to have a live transcript feed, right? So you need to be able to see all the participants, you can hear them, you need to be able to see all the documents, and you need to be able to see a live transcript feed. This one's important. You need an open line of communication with your colleagues. And I think it was Madeline that mentioned closed chat groups. One thing you need to be mindful of is on a platform such as Zoom, for instance, if you're having a private chat with the chat function, the organizer of the meeting may still be able to see what you're saying. So you need to be able to ensure that whatever communication you're having with your colleagues is secure, and we'll come to that when we discuss privacy requirements. Now, with that said, what is the ideal setup? How many screens do you need? And this is a very helpful sort of portrayal by Professor Saiz. And you can see here, well, you have obviously your webcam, your main screen to see all the participants, to see the documents, a laptop to see the live note for the transcripts, preferably an external mic or some very good headphones to minimize any interference. And you'll probably need another little screen, in this case, a tablet for the electronic bundle, and your cell phone to keep in communication with your colleagues. If a good tip here is if you have WhatsApp for web, that's a very easy and a cheap way to keep in immediate communication with colleagues as the proceedings are going on, and you have the added bonus of security as well. So this is suggesting that you probably need at least 3 screens, but it is doable if you have less than this. So now, what platform do we use? Again, and I've mentioned, does the platform support the required number of attendees that need to participate in these proceedings? Does it allow an additional channel for interpretation? Does it permit live presentation of the documents? So you need to consider this at an early stage, and as an earlier stage as possible, usually at the first procedural meeting, where each side has a chance to discuss, and you sort of identify what are the material issues that will come up. Will it be documents only, as Madeline mentioned earlier? Is witness examination required? Are expert examinations required? What sort of platform will accommodate this? And I see in the chat that Prince Benjamin says that, well, a cloud platform is preferable. It could be, it depends. So again, I'll go back to a story where in the first virtual proceedings we had to facilitate, that was an option of a cloud platform. And what ultimately put the parties off was the cost of that platform. And we ended up having to use I think it was Microsoft Teams, actually, because that accommodated everything the parties needed. It had the video conference element, it had the document exchange element to it, and it had private chat rooms as well. So cost is an element that will determine what platform you use. Privacy and security, very important here. And there are 2 aspects I want to highlight. Naturally, you want the hearing room to be secure. So you only allow those who are permitted in the arbitration to participate. But you also need to consider as well privacy laws that may be applicable. For instance, if one of the parties is in the European Union and will be exchanging documents with a party that is in Africa, then you need to consider things like the provisions in the GDPR, which prevent the transmission of data as it concerns an identified or identifiable person, unless the recipient of those data has similar protections to those that are given under European Union regulations. Likewise, you need to consider whether laws in your respective jurisdictions, there are data protection elements within your respective country. So if you're in Nigeria, you'd want to consider the Nigerian data protection regulation. But in terms of securing the hearing room, these are things with which we're all familiar by now. At the very minimum, you should have a password protected hearing rooms. The party should disclose a participant list in advance to prevent any surprises at the hearing. And like I said, be mindful of privacy requirements under applicable laws. So contingency measures in terms of technical failures. For us, being in a continent that is, well, we have connectivity issues, in some places we have also power issues. So you need to have a protocol as to what would happen in the event of a problem. In the first one we did, the protocol was, well, if one of the parties drops off, everybody has to turn off cameras and videos. Cameras and microphones. The recording was left on, so you could go back to it and make sure that nobody was communicating ex parte. And we gave the party that dropped off a time limit to join. And if they were unable to join, we would stop proceedings for an hour and then give them, the tribunal secretary would communicate with them by telephone and see if we could get back on. For us, you should always have backup devices. So from where I'm speaking to you from, we have 3 internet connections. So if one fails, we'll quickly jump onto another one. Likewise, you should have facilities for uninterrupted power supply. So for us, we have a solar inverter. So if the main grid goes off, then the inverter kicks in and we can still have that synchronous communication. And likewise, the tribunal should have alternative means of communication. So what I mean here is, if one of the parties is unable to communicate via the video conference, should we have a redundant telephone as a backup? So one of the parties could dial in and hopefully we could still see them on the camera, but hear them from the telephone connection. But very important to think of what will happen if things fail. Another thing you need to think of is how do you treat documents? Very important aspect of it, because for the online element, you do not have, well, you may have physical documents, but for the online purpose, for everybody to see where the document you are referring to, it's very likely you will have an e-bundle. So you need to determine how will those documents be shared. Madeline very helpfully pointed out the iResolve platform, which I commend very strongly. And there are other platforms as well that will have a document exchange platform on them. But if you're not using one of these more sophisticated platforms, you need to decide whether, well, are we going to have a virtual data room? For instance, should we use a Microsoft SharePoint for the central location for all the documents, or should we exchange them using a file transfer protocol? Now, if you're using an agreed bundle, another thing you need to ensure is, how do we refer to document the pages in the document? So imagine you have a compilation of documents that each side is relying on, and in each of those individual documents already have page numbers. Then in your compiled documents, that also has page numbers. So something you may not think about is, well, which page references are we referring to? Are we referring to the page references embedded in the original documents, or are we referring to the page references in the newly created documents? That will save you a lot of time and a lot of problems if you decide that as early as possible, because you don't want a situation where one side is referring to the embedded numbers and the other side is not quite following where to go. And also consider, in addition to the electronic bundle, also provide a hard copy bundle to each of the parties, particularly where the witnesses are in different locations. And if one of them has a problem accessing the e-bundle, or they do not have screen real estate that will accommodate it, at least they have a hard copy that they can refer to. Also agree on a protocol for delivery, right? Are you going to deliver solely electronically or electronically and in hard copies? If you are delivering in hard copies, particularly to a witness without the assistance of counsel, it may be worth having that witness undertake not to access the bundle before testifying. Video and audio directives is a practical consideration you want to also think about. Should all the participants always have their cameras on? Now, imagine it's a big arbitration, you have up to 30 people. It might be a bit distracting to have 30 cameras on at the same time, trying to pick out who is talking at any given time. So your protocol might be to say, well, only active speakers should have their cameras on. So in a hearing scenario, you might want to limit that to the tribunal, the witness, the examining lawyers. Now, also have a protocol for what do you do if you want to raise an objection. So while a witness is testifying and counsel wants to raise an objection, how do you do that? So it could be as simple as, well, if your camera is off at the time, turn it on, and it will bring the tribunal's attention that you wish to make an intervention. Or you could use the hand raise function, which is available on most video conferencing platforms. So for witness examinations, the practical considerations here that you need to ensure that you have the best possible video and the best possible audio quality while connecting. You may not necessarily have and equal technology with your counterparty, particularly if they're in a jurisdiction where technology has become the mainstay. Nevertheless, you need to ensure that whatever technology you're using and whatever connection you have, it is the best possible connection you have. So I need to be able to see the witness and hear them properly and immediately as well. If a witness can leave home, then consider whether it might be a good idea having them testify from a neutral location. So for instance, they might go to a law firm or a hearing center if one is available. Alternatively, you could also consider having one of the party representatives present where the witness is to assist with logistical issues, with technological issues. So not only, as Madeline said, should the tribunal be tech savvy, the counsel should be tech savvy as well in order to assist their witnesses and clients where necessary. Something else you need to think of is the parties in different time zones. And if they are, which time zone should govern? So one way I've seen it done is to say, well, the time zone of the seat should determine when the proceedings will take place. But if you have extreme scenarios where you have one party, for instance, in the East Coast, or sorry, in the West Coast of the US, and you have another party in Asia, then those very extreme time differences could occasion some hardship. So you may want to spread the difficulties equitably. And what I mean by that is if one party testifies very late at night on one day, then ensure that on another day they're given a very or a more favorable time slot. Objections I've mentioned, it's very important to establish a protocol for mentioning objections, because you want to keep the proceedings as orderly as possible. If I just jump in and start making objections, it makes the hearing quite incomprehensible when you have people talking over each other, particularly over an online platform. Again, hearing times, I've already mentioned this. For the host, you need to determine who will host the proceedings and what level of control do they have. If you're using an arbitration center, then naturally they will host it for you. If you are not, because of costs, well, you need to determine who will host. Should it be the tribunal? Should it be only the presiding arbitrator? Should it be a tribunal secretary? What level of control will they have? Should they be able to mute microphones, turn cameras off, on and off? And again, why this is important is from a war story I've heard, the tribunal in a particular case turned off the microphone of a party that was being disruptive. And that led to that party challenging, and I should say unsuccessfully, challenging the proceedings on the ground that the tribunal prevented them from being able to present their case reasonably. But if you establish this at the very beginning to know that, well, if a party is being disrupted, the tribunal can turn off microphones, can turn off cameras, then you manage expectations, and it doesn't come as a surprise to the parties if that happens. Bear in mind that online fatigue is real. So hearing days might have to be shorter, particularly if you need to accommodate different time zones. And take frequent breaks just to allow the parties to sort of rest their eyes, stretch their legs, etc. Madeline mentioned this, and this is very important. You need to be able to narrow the scope in virtual proceedings. So as an example, there's an arbitration in which I've just been involved, and one of the parties didn't quite get this message and wanted to put in as many documents as possible, even documents that did not go to any disputed issues. And what that will do, it will prolong the proceedings. It will make it more complex than it needs to. Think the simpler, the better. So if you're able to narrow the scope and focus only on the evidence that can't be dealt with exclusively by documents, then it will make it more efficient, right? So you just focus any witness hearings to those disputed issues and try and make it as streamlined and as efficient as possible. In terms of helpful resources, you've already heard some of them from the other speakers. I commend in particular the African Arbitration Academy protocol on virtual hearings in Africa. But there are very many others, particularly now as we are going through as virtual proceedings are becoming more of the norm rather than the exception. So each of these you'll be able to find online, and they provide very helpful guidance as to what sort of protocol should you adopt in virtual hearings. So I'm mindful of the fact that I want this to be more of an interactive discussion rather than me just talking to you. So I hope this has sort of stimulated some ideas in your head, and I look forward to any questions you might have regarding some of the practical aspects that might arise during virtual proceedings. So thank you very much, and Abayomi, back to you.
Thank you very much, Isaiah, for, again, those useful insights. I see a couple of questions in the Q&A box. I'd promised that we will not use more than 1.5 hours. So right now we're going to about 2 hours. So I think we have just 10 minutes to take those questions. So what I would just do is to ask those questions and allow the panelists to intervene. Isaiah, there's a question for you in relation to cybersecurity concerns. So how do you sidestep those concerns? Prof, as in addition to the first question I asked Prof, there's a question from Dalila Yushra that says, will you please tell us about your opinion on the enforceability of smart contracts, blockchain technology, and the predictable risk of them? So those risks implicated by those kind of contracts. And Madeline, there's a question for you that how would the arbitral tribunal deal with illegally obtained evidence through Akin? Would the tech expertise report suffice to actually establish proof of the hacking to prevent the other party from relying on it? And Prof, last question, when Isaiah was speaking, he spoke about on the question relating to whether the arbitrator should proceed remotely or with virtual hearing if one of the parties object. I know you published the Wahab pandemic pathway. You may have an intervention in relation to that question. And so we'll start with Prof, then Madeline, then Isaiah, then we'll call it a day.
Thank you very much, Abayomi. I very much enjoyed the presentations of my colleagues and your very capable moderation. I will be very brief in response to the questions so that we have time as well for Isaiah and Madeline to address the questions. So your first question was basically ODR potentially taking over, and where does Africa stand there in terms of the technology? Let me tell you the following, of course, and I'll be very candid. Africa is the last standing continent with the greatest potential of investments, a green field. So all eyes are on it. And every person or entity across all continents have a vested interest in investing in this. So I think Africa is booming and a lot is already taking place. Where do we stand? Of course, we are lagging behind in terms of the technology, especially secure servers and connectivity issues across the continent at large. There are, of course, hubs where we see certain parts, of course, Nigeria, Egypt, South Africa, Rwanda, Kenya, where they have, made leap steps in terms of ensuring that they're aligned to an extent with best practices in this respect, but still a lot remains to be done. So I think, and that's one of the potential areas. I think traditionally we think of course, infrastructure, construction, and energy, but I think telecommunications and ICT is an area where we will see a boom in terms of the investments. And that's an area where, of course, African free trade, the Continental Free Trade Agreement will play a key role. So I think it's a lot, we can expect a lot more in the coming few years. In terms of the blockchain technology and smart contracts, let's remember one thing, that smart contracts normally are self-enforcing. The whole idea of smart contracts is that you wouldn't need to go for an external type of enforcement mechanism one way or the other. But that said, and with blockchain, which is a huge boom, and I think many people have now vested interest, still they're not risk-free, of course. And the way, for those of our colleagues who are not aware, basically blockchains is based on a distributed ledger technology, where we have blocks and every change in one block is seen and impacts a change in another block. And so it's not in one location where you do a change, it cuts across the whole network of connected computers or devices in this respect, which makes it difficult to make an unnoticeable change or tamper with it. And that, I think, is one of the high watermarks of the use of this technology. Nevertheless, nothing is risk-free, be it in terms of technology or traditional ways in a way. If we consider the risks of blockchain, I think simply the lack of standardization is an issue. We see that there is a lack of standardization across those engaged in blockchain. There is also no uniform valuation of cryptocurrencies generally. So we have underdeveloped standards, no uniform valuation of cryptocurrencies. We have protocols that may not be easy to integrate in each blockchain. And of course, there are human-related risks. So hacking is not impossible, but difficult. If you engage in hacking, this means you have to alter each and every block in the blockchain itself, which is not easy. And of course, you have risks of public and private key and risks of vendors and untested codes. So pretty much very technical. On the legal risks, I think data privacy and regulatory risks remain at the high end, because not many countries have regulated this so far, and privacy issues remain at the forefront of those risks. This is by and large my response to these questions. Now, in terms of Isaiah's excellent presentation as well on virtual hearings, yes, I did write the pathway, and you are kind, of course, to have a commentary published as well on this. And I think again, the essential question is what happens if the parties disagree? And here I can refer people to my publication where I identified a number of criteria on the basis of which tribunals would need to navigate their decision. And of course, one aspect which is interesting, people may see different perspectives. Do we have a legislative coverage that enables the tribunal continue, or do we have a legislative prohibition to prohibit the tribunal from continuing? Depending on the jurisdiction, the general answer is that absent a prohibition, depending of course on the legal system, the tribunal has discretion. But in doing so, you have to consider elements, of course, of due process availability of technology. There are certain parts, at least on the continent, where people don't have connections. So how can you enable a party to present its case absent a connection? That is distinct from using state-of-the-art technology or a reliable technology, because you will always have variations across parties as to access of technology. But the question really is whether we have sufficient technology to enable a reliable connection for a party to present its case. I think COVID has taught us that in certain situations, it is unavoidable to hold a hearing virtually, and people have navigated their way in this respect. I've had a number of hearings where even though one party could not access or had no reliable connections on the continent, they traveled to a neighboring country to join. So close enough, you made the trip to a neighboring country to be able to have a reliable connection. And on the point that Isaiah helpfully mentioned, which is populating the screen with many access points, again, practice has shown recently that people join from what they call remote hubs. So you'd have counsel team joining from one hub, so you can see one screen where counsel together in one place or an expert in another place. So there are ways to deal with that. The question, of course, is a post-COVID, whether it would continue. And I'm saying it's going to be an option alongside physical hearings. Of course, post-COVID, people would want to meet physically, so there will be a surge in physical meetings and hearings, but virtual hearings or hybrid forms are not going to go away.
Thank you very much, Prof. Madeline?
Thank you, Abayomi. Well, your question really is very complex. I would say that there is no particular way to approach it in terms of how an arbitral tribunal should handle or will handle when it does happen that there is illegally obtained evidence through hacking or any other means. because it could be not even from the hacking. It could be through other methods of cooking up some evidence that could render it to be illegal. Now, with an arbitral tribunal, most legislations which have adopted the model law, the arbitral tribunal has power to determine the admissibility of evidence. And the approach that I would say would be that this should be handled on a case-by-case basis, depending on the facts before you, in order to minimize the risk of that award being either challenged in any sort of way for ignoring any particular documentation or evidence that has been tabled before it. I think that arbitral tribunal would have to tread very lightly in terms of determining whether to apply that evidence or not. Now, applying it, of course, the relevance, the materiality of it all, whether it has an impact on the outcome of the dispute, all these factors, or even the severity of the illegality needs to also be looked at. Now, if you have this tech expertise report that gives you sufficient proof of the extent of that illegal evidence, then that could be something that could make some sort of weight to the arbitral tribunal's decision making in terms as to whether to take it into account or not. I was looking at the Article 9, subsection 3 of the IBA Rules 2020, and that wording that is provided there, it says that it may, at the request of the party or in its own motion, exclude evidence obtained illegally. And so if that particular arbitral proceedings have adopted the IBA rules, especially the new 2020 version, then they would have that option there in terms of assessing the risk aspect that could come around to the award if that particular evidence is ignored or taken into account. And of course, the national laws, I would add, something that would have a major impact on the decision making of the arbitral tribunal, because some national laws do provide for admissibility of evidence in arbitrations. Yes.
Thank you very much, Madeline. Isaiah?
Thank you very much, indeed, Abayomi. So in relation to how to avoid security risks in the arbitral proceedings, I think the first thing to ensure is you need to identify what are the points that the information leak is most at risk. So there are two levels you need to consider. You need to consider communications within your own team. So communications from your client to yourself. And then you need to consider communications within the arbitration itself. So, there are very practical things you should do. If you are sending documents through email, for instance, do not use unsecured platforms. So do not use, for instance, the commercially available ones like Yahoo Mail, Gmail. Ensure that whatever system you are using has sufficient encryption to prevent a data leak. Likewise, the virtual platform you are using, ensure that the encryption, again, is sophisticated enough to prevent a data leak. And one thing we have to be mindful of is whether the proceedings are virtual or physical. If one of the parties or if a third party is motivated enough, they would probably be able to access those proceedings in one way or the other. It's literally a case of what steps do we take to mitigate those risks from happening. One other thing to consider is if in the event there is a data leak, should cost sanctions follow? So if there is a major data leak, should the tribunal be empowered to sanction a party with costs? That might be another way of motivating the parties to ensure that in exchanging documents and sending sensitive information, they have taken sufficient measures to ensure that that transfer is secure to prevent the risk of a data leak. And if I may just briefly comment on the question put to Madeline, there are some jurisdictions, and I'll use a Nigerian example, for instance. On the Nigerian law, illegally obtained evidence is admissible. So that might be a factor that might motivate tribunals thinking if they are influenced strongly by the legal backgrounds from which they come. However, I have seen, and this was in litigation, but I have seen where illegally obtained evidence is admissible in order not to encourage that, in order not to encourage the steps of illegally obtaining that evidence, there were quite heavy cost sanctions on the party that took the steps to obtain that evidence illegally. So that's another aspect I've seen.
All right, thank you very much, Isaiah. And given time constraints, I think this is a very good place to draw the curtain. Thank you, Prof, Madeline and Isaiah, for taking out time out of your busy schedules to speak to us today on these important topics. Many thanks also to all the attendees for being part of the session and for those useful questions and contributions. I know lots of people have been asking questions about the recording and the slides. With the kind permission of the panelists, we'll be sharing the slides and the recording with the attendees and those that registered and couldn't attend. The training continues tomorrow for the Portuguese-speaking practitioners in Lusophone Africa. I know one of the speakers for tomorrow, Luis Abram, is also one of the attendees today. Thank you, Luis, for joining. And we'll also be doing another session for Francophone Africa in the next few weeks. So thank you very much for joining. Enjoy the rest of your day. Stay safe, and bye for now. Thank you.